We ask that you deny Mr. Gough's motion for mistrial. There's absolutely no evidence here that the jurors have been influenced in any way by the first and only larger crowd that came yesterday. No evidence that they even knew it was out there. No evidence that they have been intimidated or influenced in any way. Mr. Gough then says witnesses are subject to intimidation as well. No evidence has been presented of the witnesses coming into this courtroom having been intimidated in any way, shape, or form. And then he brought up the court itself and intimated that the court might have been influenced by all of this.
I object to that. That's a mischaracterization of the motion.
It's on page 6.
Yes, I'm aware. I wrote it this morning. It doesn't say that. It says that the concern is that people are attempting to influence the presiding judge. That's not saying that the judge is being influenced, but I'll come back to that when I have the last word.
Your Honor, Mr. Gough is a brilliant lawyer. These briefs that he has filed are detailed, and he has filed a ton of pretrial briefs that the state has had to respond to. He is very, very smart. He is very, very calculating, and he's a good lawyer. Because on November 12th, he stood up in this courtroom, knowing full well he was on television, and made comments about Al Sharpton and then black pastors and Colonel Sanders, all knowing full well it was being broadcast on television. That was not ineffective assistance of counsel by any stretch of the imagination. That was strategic. He got the response he wanted because he has filed a motion a day based on a continued drumbeat of, well, see, people are coming and people are responding, but they're responding to what he did. They're responding to what he strategically, knowingly, intelligently did so that there would be a response so that he could then complain of it. That is good lawyering right there, because now he's motioned for a mistrial based on something that he caused. You cannot insert reversible error into the case yourself. You can't go ahead and do something and then go, oh, well, it's reversible error when you're the one who did it. But he is attempting to go ahead and do that, which, by the way, once again, not ineffective assistance of counsel, brilliant lawyering, and we ask that you deny his motion for mistrial.
Of all the things I've been called all around the world of the last month, I don't think brilliant was any of them. But let's take this up, Your Honor. The motion was legitimate. I didn't ask for anything that wasn't done in federal court 30 years ago. Because it was intuitively obvious then that it's a problem. It's intuitively obvious today that it's a problem, and it has been. The idea that a lawyer standing up to defend his client with appropriate motions made in a courtroom somehow can waive the client's rights by having raised the issue, that's a troubling concept, Your Honor. And let's be clear, this motion is not a motion to recuse. We have never filed a motion to recuse in this case. We've never even suggested that the court should do so. We've asked all the court officers in this case to disclose any basis that might arise, and we assume that when we don't receive information, that there's nothing to discuss. That's not the issue. The issue is the attempt of people in the media, or people using the media, particularly people that are associated with the Arbery family or their lawyers, whoever it's coming from, however it's coming, there is pressure being exerted on these jurors. There's pressure, consciously or unconsciously, being put on witnesses. There's pressure, conscious or unconscious, being placed on this court. That is the problem. It doesn't matter whether the jurors are being influenced. It doesn't matter whether the court is being influenced. It doesn't matter necessarily that the witnesses are being influenced. But it does raise serious questions about the propriety of the proceedings and the integrity of the process itself. It is unfortunate that this case raises in a way that maybe hasn't come up before, with the activities of third parties. Now, I'm not saying that the state had no role in any of the stuff that's gone on in media frenzy or the GBI from the beginning of this case, but obviously much of what's happened is the result of third-party activity in this case, spectator activity, for lack of a better phrase. The state's fundamentally mistaken, and I think the court is not giving full credit to the argument that's being made here. Yes, if there's actual prejudice here, if the jurors are all staying up saying they can't be fair, if Your Honor were to stand up saying you couldn't be fair, if a witness were to stand up saying I can't feel like I can tell the truth, that would be actual prejudice. And we wouldn't be having this discussion. The court would, on its own, sua sponte, be taking appropriate action to ensure the rights of these defendants. I have no doubt about that. The question here is inherent prejudice. That does not require any affirmative activity in the gallery. It doesn't require any affirmative statements of jurors or anybody else. The argument is that it is inherent prejudice. Now, this is not 1915. This is not 1923. There are not thousands of people outside with pitchforks in baseball bats. But I would respectfully submit to the court that this is the 21st century equivalent. This case has been infected by things that have nothing to do with the guilt or innocence of these defendants, largely without as far as I can tell, it's not like the state is out there during this trial giving press conferences or something, but still, third parties are influencing this case. They've been doing it from the gallery in this courtroom. They've been doing it outside. This is what a public lynching looks like in the 21st century, with all due respect. They don't have to have 10,000 people outside. They don't have to have 100,000 people outside. Perception is reality. We have sealed these jurors off. We hope we have. We have sealed them off. And it doesn't matter how many people are outside. It doesn't matter how violent they appear to be. It doesn't take much. And you've got witnesses and you've got jurors who are worried about their careers and their livelihoods when this case is over. And they'll be aware of what's going on. They certainly were aware of it before they got here. They talked about it during the voir dire process. Just because they haven't put a gallery up, they haven't put a podium up outside with a hangman's noose on it, doesn't mean that this isn't a trial, despite the best efforts of this court. This isn't a trial that's been infected by mob violence of a woke left mob. And whether people realize that they participated in that or not, I'd like to think that the vast majority of the people outside this courthouse really have no interest in anything but justice. I want to believe that. From a lot of the people I know out there, I think that's true. But the perception is the reality. And the media have fed that perception and created a reality, whether it's true or not. Just like other people have created a false narrative, and the falsity of that narrative has been made very apparent through the trial of this case. That becomes the reality. This is what a mob-dominated trial looks like in the 21st century, and we're asking for the mistrial.
All right, the court, having heard from the movant as well as the parties, denies the motion for mistrial. I think the court's position has been accurately stated previously. I thought it appropriate, given the mistrial filed, that we have it on the record. We're going to take a lunch break.
Hi, everyone. George Stephanopoulos here. Thanks for checking out the ABC News YouTube channel. If you'd like to get more videos, show highlights, and watch live event coverage, click on the right over here to subscribe to our channel. And don't forget to download the ABC News app for breaking news alerts. Thanks for watching.